Hi, everyone. We're going to get started in just a couple of minutes, letting folks roll in. Excited to have you here. I think we'll give it just another minute or two, and then we can get started. Hey, for the people who just joined, we're just going to give it a couple of minutes for more folks to join, and then we will get started shortly. I think we can go ahead and get started, and then if people roll in, they won't have missed too much. So hi, I'm Shloka. I'm the volunteer coordinator at the AIDS Legal Referral Panel. Super excited to have all of you with us here today, and to hear this presentation from John Unruh regarding VA disability benefits. So a quick little agenda. I think some of you on the webinar are new to ALRP, which is great. So I'm going to do a little introduction to who we are and how our panel works. And then we'll get started with John's presentation. We'll have time for Q&A afterwards. And then, this is kind of important. The Zoom, when you exit, will redirect you to an evaluation form. Please make sure to complete that, because that's what will sort of prompt me to send you your certificate of attendance for CLE purposes. If for some reason you don't get the link or can't access it, everyone should have my contact information from when I sent out the materials earlier today. So please reach out directly if for some reason you can't access the evaluation form, or you didn't receive the materials, etc. Some quick housekeeping. This is being recorded, and we'll share the recording out afterwards in case you feel super invigorated and want to watch it 3 more times in a row. Participants are muted, but we have the Q&A function open. So please, if you have questions, enter them there, and we can sort of take those as they come in, or we'll also have time for Q&A at the end, depending on what makes the most sense. As I mentioned, please complete the evaluation form. It should take like a minute. And if you have any other questions, I'm happy to help. So a quick introduction to ALRP. ALRP was founded in 1983, so we are marking our 40th anniversary this year, which is a little bit astonishing. Our mission is to help people living with HIV maintain or improve their health by resolving their legal issues. When we were founded in 83, a lot of what our volunteer attorneys were doing at that time was really sort of going out and drafting emergency wills for the community when people, knew they were dying very quickly. Thankfully, that landscape has changed since that time, but there are still, real challenges associated with managing a chronic health condition that can be exacerbated by stress or by housing instability or by immigration concerns, and so on. So what our role is these days is sort of helping our clients address their legal issues so that they can achieve the stability that they need to maintain their health and to thrive. We do that in two ways. So first, we have about 15 in-house staff attorneys who are primarily working in housing, although they do have other areas of expertise as well. And then in addition to our staff who can handle matters in-house, we also have a panel of several hundred volunteer attorneys who we can refer clients to really receive a breadth of civil legal services. Our panel attorneys, run the gamut from family law to immigration to credit and bankruptcy to really the full spectrum of civil legal services are within their scope, which is great and super useful in terms of providing our clients with the services they need. So just a few numbers. Since our founding, we've handled over 80,000 legal matters for people living with HIV or AIDS in the San Francisco Bay Area. These days, about 85% of our clients have an income of $30,000 or less. So the free and low-cost legal services that our panel provides are super critical in helping meet their legal needs. A quick pitch. So we do these trainings for, I guess twofold reasons, right? Like A, we do just want to increase the capacity of people serving our community. But B, we are hoping, if you are not already a panel attorney, you may be interested in joining us. I think many of our existing panel attorneys will attest that it's a positive experience for them, that it's a way for them to meaningfully contribute to the community, that it's been a positive experience for them. I think it's also sort of as small or as large a commitment as you would like it to be. So in general, we ask that panel attorneys accept 2 referrals a year, but you always have the option to say no, either because something's, well, for whatever reason you want, we're not going to hunt you down. But if something's outside of your wheelhouse or you don't have capacity, we will always check in with you first before sending you a referral. And we'll sort of on our end do an intake with the client, identify their legal need, find an attorney with the relevant expertise, reach out to them and ask for confirmation before sending anyone your way. So you'll never be, bombarded with unsolicited referrals. We also have, these MCLE trainings available for current and prospective panel attorneys. We can connect you with mentorship or networking with other attorneys if that's something that would be helpful for you. We have other resources available. So hopefully it ends up being a mutually beneficial arrangement for everyone involved. So that's the end of my little segment, but if you are interested, I would love to hear from you. There's more information on our website, and you can also reach out to me directly, and I'm happy to talk more or answer questions. Cool. I'm going to hand it over now to our presenter, John Unruh, who is a attorney based in, I have a little bio here, it's disappeared. He is, got it. He is an attorney based in San Francisco with a practice focused on disability and family law. Before opening his own law office, he was a staff attorney at Swords to Plowshares, a nationally recognized veterans' rights organization. John received his JD from The Ohio State University Moritz College of Law and has a BA in art history from Berkeley. He's been a panel attorney with ALRP since 2012 and has also served on our board of directors since 2019. And we are super excited to have him here today and to learn from his presentation. Take it away.
Okay. Hi, everyone. Good afternoon. Please don't hesitate during the presentation to raise your hand or ask Q&A. This area of law, if you're not familiar with it, can be a bit confusing. So I'm happy to answer questions as they come in. You don't need to hold them to the end. So yeah, there was just a brief bio on me. Yeah, I used to work at Swords to Plowshares, which many of you, if you're in the Bay Area, may be familiar with. That's how I got into the area of VA disability benefits law. I left Swords in 2013 after being there for about 6 years and started my own practice. That bio is a bit old in that I no longer practice family law. I'm now exclusively VA disability benefits, and I also do some long-term disability ERISA litigation for under private insurance claims. And then also here and there, I do some FDCA claims against the Department of Veterans Affairs, which is the Federal Tort Claims Act. So basically, if a client is injured at a VA medical facility or a VA facility, and they want to sue the VA for money, that is another area, a sort of subgenre in which I practice. Yes, I'm on the ALRP board. ALRP is a great organization. I highly encourage everyone, if you're not, to become a panel attorney, to get more involved in the organization, to come to the 40th anniversary celebration next month. I'm also on the small and solo law firm executive committee for the Bar Association of San Francisco. I'm on the Bailiff Foundation board, which is the San Francisco LGBT foundation arm of the Bar Association. And something I'll mention in more depth a little bit later is I'm involved in NOVA, which is the National Organization for Veterans Advocates. I've been a member of them since 2007, since I started at Swords. And I'm on their Rules and Regulations Committee. If any of you are interested in doing this area of law in your own practice, I would highly recommend you get involved in NOVA. Okay, next slide. Okay, so let's start with the basics. What is the VA? The Veterans Administration is now referred to as the U.S. Department of Veterans Affairs. It's sort of it was created by President Lincoln after the Civil War, and it's sort of broken down into three sub departments underneath the VA. There's the VHA, which is the Veterans Health Administration. They oversee all VA medical facilities, all the clinics, all the medical centers that are scattered throughout the country and elsewhere that care for our veterans and their families and provide health care. The VBA is the Veterans Benefits Administration. That's what we'll be primarily talking about today. They are the organization that oversees the administration of benefits and adjudicates the decisions and claims that we'll be talking about today. And then there's the National Cemetery Administration. They oversee the cemeteries, the national cemeteries throughout the country. There's one here in the Presidio that you've likely seen if you're in the Bay Area. And they handle giving burial plots and handling burial expenses for our nation's veterans. Okay, next slide. Okay, so VA benefits. This is a rundown of the types of VA benefits overseen by the Veterans Benefits Administration. The two big ones are VA pension and VA compensation. VA pension is a means-tested benefit for low-income veterans, and the underlying condition that renders someone disabled does not have to be related to the veteran's service time. We'll talk a little bit about pension in a bit, but this is definitely the lesser benefit that the VA supplies to veterans. And if you're familiar at all with Social Security, pension is related to sort of supplemental security income, or SSI, as you have to be unable to work to receive it, and you also have to be of limited income. There's a few more eligibility requirements that we'll talk about in a bit, but that's the basics of pension. And I don't handle really pension claims. VA compensation, this is where 99% of my clients come to me for help with their VA disability pension compensation claims. And this is a type of benefit that the VA provides to a veteran to compensate them for a medical condition or a disability that is connected to their time in the service. So it has to be quote unquote service connected. We'll spend a lot of time this afternoon talking about what that means to be service connected. And the big thing with compensation is that it is not means tested. You can be earning $1 million a year at your job and still be entitled to receive VA disability compensation if you have a medical condition that is related to your time in the service. There are benefits that dependents are entitled to, including spouses, dependent children, dependent parents. Then there's healthcare, education, home loan, life insurance, and then burial and memorial services. But we're, again, going to be talking primarily today about compensation and a little bit about pension. Okay, next slide, please. So what does it mean to be a veteran? You may think the definition is quite common sense, but if any of you have practiced in the area of federal benefits, you know that nothing is common sense when it comes to that area of the law. So first, the basics of eligibility for any of these benefits is that the person has to be a veteran, and that doesn't necessarily mean that they served in the military to have veteran status. For federal service, these are the branches of the government, or excuse me, the military. There's the Army, Navy, Marines, Air Force, Coast Guard. Also, there's Space Force now, which is sort of a subgenre under Air Force. And the person, in order to be a veteran, has to have quote unquote honorable service. And that means that a person served in the active military, naval, or air service who was discharged under conditions other than dishonorable. So it's defined in the negative, but essentially what that means is that their service was either honorable or general. And then there's not a statutory bar to veteran status either. And that would be a conscientious objector, someone who went AWOL for over 180 days, which is an unauthorized leave of absence, or if someone was a conscientious objector. You don't see too many of those. And if you are doing this type of law, most people coming to you will have an honorable or a general discharge. You do see some with other than honorable discharges, which is a bar to benefits. And we can talk about that more in a little bit. Where it can get really complicated is if you have someone who comes to you and they only have National Guard service. In order to qualify for veteran status with a National Guard member, it depends on how much active duty they have and active duty for training. And if they were mobilized, whether they were mobilized by the state or by the federal government in order to obtain veteran status. That's probably way more than you ever need to know if you're just going to be doing the basics, but just know that if someone does come to you and they're seeking veterans benefits and they only have National Guard service, you may need to really look into what type of service they had and if they were activated, whether it was by the state or federal government. Next slide, please. So a VA character of discharge evaluation, well, backing up a bit, what we just talked about in terms of discharges, that comes from the military, what the type of discharge someone has. For VA purposes, if someone has a honorable or general, they're automatically qualified for VA benefits. If someone has other than honorable, bad conduct, dishonorable, or uncharacterized, the VA has to make what's called a character of discharge determination in order to determine if that person is qualified for VA benefits. This is a sort of a separate adjudication process that has to happen for someone who doesn't have a general or an honorable in order to make them eligible for VA benefits. Usually if someone has an OTH or a bad conduct, you need to come up with mitigating circumstances to explain why that person should be entitled to VA benefits despite their unfavorable discharge. It's a high bar to meet, but a common fact scenario would be someone is mobilized, goes overseas, sees combat, has very good markings, evaluations up until their combat experience, and then they start their performance starts suffering. Maybe they start self-medicating with drugs or alcohol, and then they're discharged with a general or an other than honorable discharge. You can maybe obtain a psychiatric evaluation that says that they were experiencing the first effects of PTSD. They were self-medicating with alcohol. That explains the behavior that led up to the OTH. And before their deployment, they had honorable service. Therefore, the VA should allow this person to receive benefits. That's a common scenario that you might see when someone comes to you with an OTH. But just know that if you ever deal with having to having to advocate for a favorable character of discharge evaluation, it does not underline or does not overturn the underlying discharge provided by the military service. There is a whole separate adjudication process that you can do through the military, through the Board of Corrections, naval records or military records, where you can have someone's actual discharge overturned on a similar fact pattern, but a VA character of discharge evaluation does not change the underlying discharge. It only makes that person who would otherwise be ineligible eligible for VA benefits. Again, if you're just starting out in this area, this is not really something you're going to get into, but it's just sort of a threshold issue that you need to be aware of, that there are some people who served in the military who don't have quote unquote veteran status because of the characterization of how they were discharged out of the military. Okay, next slide, please. Okay, so pension, real quick. Pension will be more common if you're working with low-income veterans or homeless veterans. Pension, again, is the means tested benefit that the VA provides. You do have to have veteran status. There is a time and service requirement. Prior to 1980, it has to be at least 90 days of service on active duty. Since 1980, it changed a bit. September 1980, it has to be at least 24 continuous months. Continuous is important, or completion of a time ordered to active duty, or you have to have a compensable service-connected disability, which we'll talk about in a minute. To be disabled, you have to be permanently disabled for any reason. Again, SSI is, if one's eligible for SSI, they're usually going to be eligible for pension. And disabled in sort of both administrative processes means that one is unable to be gainfully employed due to a medical condition or disability. Gainfully employed is usually they cannot work on a sustained basis and make enough money to meet the poverty threshold, which right now is, I believe, around $1,100 or $1,200 a month. For pension, the alternative to being disabled is to be at least 65 years old. So current rates, well, this isn't current, this is last year, but so it's probably gone up a little bit. But monthly income, so correct what I just said, monthly income, you have to have under $1,597. So someone has to have under $1,597 in income from benefits. Various benefits would count as income. It's any income. It's not necessarily from an employment. They have to be receiving under $1,597 a month, and they can't have assets over 138. Again, these numbers are probably a little bit higher now because of inflation, but these are the numbers as of December 2021. And there are offsets you can make for various expenses. Again, this is very similar to qualifying to SSI. And this part's very important. They have to have at least 1 day during a declared wartime period. So next slide. What is wartime? These are the periods of wartime that you will encounter today. World War II, there's still some of those veterans out there. The Korean conflict, Vietnam, and then Persian Gulf. And yes, Persian Gulf, we have been technically at war since August 2nd, 1990, when Congress authorized the war in the Persian Gulf. That has never been sort of discontinued. So anyone who's served since 1990 is eligible for pension, at least based on the 1 day in a period of war conflict. And then these are the other dates you need to look for. Just note that there's a whole generation of veterans between May 7th, 1975 and August 2nd, 1990, 15 years, a little over 15 years there, where anyone who, if they just served in that period, is not eligible for pension, regardless of their income or medical condition, just by the virtue of the fact that they didn't serve at least 1 day during a period of war. Okay, so that's all we're going to cover on pension. Again, you likely won't see this unless you're dealing with very low income individuals or homeless veterans, because the compensation is definitely the better benefit of the two. So we're going to turn to that now. Next slide, please. So VA disability compensation is meant to compensate a veteran for their reduction in earning capacity caused by their military service. And unlike SSDI, which some of you may be familiar with, it's not something you're either eligible for or not eligible for. There's stages along the way, and it's awarded on a percentage basis between 0% and 100% in 10% increments. Do you need help going back to the slide? Oh, here, okay. Awarded on a percentage basis from 0 to 100% in 10% increments, with 100% being considered completely disabled and unable to work, and 0% being there is a medical condition that you might have that's related to the service, but we're not going to pay you anything because we don't think it actually prohibits your earning capacity. At least that's the rationale provided in the regulations. And note that not each disability is rated at each increment. We can talk about that more in a little bit. And these are monthly payments received by the veteran, and they are tax-free. Next slide. So to be eligible, you have to have a veteran. There is no time in service requirement, but you have to meet that quote unquote veteran status that we talked about earlier. The condition has to be service connected, which means you have a current disability or medical condition that is incurred or aggravated during service. So that means it either began in service or you can link it to service through chronicity, or what's called a nexus, that you have a condition today that began or originated in the service, or if it's a pre-existing condition that it was aggravated during service and has continued to the present. And then you have to have a rating. So again, based on the severity of your symptoms, the VA will assign a rating between 0 and 100% for the condition. Okay, next slide. So to have a viable claim for service-connected disability compensation, you need 3 elements. You need an in-service event, injury, or diagnosis, a current disease or disability, and a nexus between the two. So some very straightforward, examples would be if a veteran lost a limb in service, say their right forearm. Obviously, that one's going to be pretty easy to service connect. If it's documented in service that they lost their right forearm, 20 years later, they apply to the VA and they still don't have their right forearm, it's not that hard to connect the two. They lost the forearm then, it hasn't grown back, and it's related to the service. I don't think the VA would get that one wrong. It's more complicated when it's a knee condition, a back condition, a cervical spine issue, hearing loss, a mental health condition that maybe the stressor occurred in the service, but actually the symptoms didn't manifest till 5, 10, 15 years later. That's when the VA is going to have a lot more difficulty in doing what's called service connection, finding the nexus between the two. And that's where your skills as an attorney and an advocate can really come into play. Okay, next slide, please. So incurred in or aggravated during service. This can be shown by lay evidence of the event, corroborated by objective evidence. So what that means is, there may be medical evidence in the service records. Most veterans will have service treatment records for when they were seen by medical in the service. If there's a documented injury in there, that's going to be great evidence that the condition began in the service. Or there could be medical evidence of illness during a presumptive period. There are certain conditions and diseases that if they manifest immediately after service, they're presumed to have been incurred during service. Some of these are multiple sclerosis, rheumatoid arthritis, a paranoid schizophrenia. Some of these conditions, if they manifest immediately after service, which is usually within 1 year, you can get service connection based on that presumption. Most conditions, though, you need to have sort of an in-service document showing that the condition began in the service, or you need to have credible lay evidence that something began in the service. Note that all veterans entering the service are presumed sound, and this is a very powerful presumption. It means that unless there's a clear medical diagnosis that a condition pre-existed the service, every veteran or every person who enters the service is presumed to not have any medical condition. And then this is a bit of a wrinkle to everything. It's not a result of willful misconduct. You're not going to see this too often, but an indication of that would be, say, in the example of the person lost their forearm. They lost their forearm because of a drunk driving accident, where that would be considered willful misconduct. But, a further wrinkle to that would be, well, maybe that person was drunk because they were self-medicating with alcohol because they had extensive PTSD because of their combat experience. That could maybe be a way to get out of the willful misconduct. That's me just making up an example. But just do note that there is an exception that a veteran can't receive compensation for a medical condition that's the result of their own willful misconduct. Okay, next slide, please. So the veteran needs to have a current disability in order to be rated. I mean, this makes sense, right? According to the VA schedule, you're only going to be compensated if you have a current medical condition that's disabling, at least to some degree. For mental health conditions, which a lot of the veterans, at least that seek out attorneys, have a mental health claim, you rely upon the DSM, and right now we're on DSM-5. And you need to prove, again, a connection between the current diagnosis and the time in the service. And that's done usually through medical evidence. In addition to having direct evidence, which would be, or direct service connection, which would be in the instance of, like say, PTSD, where there was an in-service stressor and someone has a current diagnosis of PTSD, and a medical doctor says that the PTSD is caused by the stressor in service. You can also have secondarily service-connected conditions. An example of this would be if the individual with PTSD also has a migraine condition that's caused by their medication that they take for PTSD, or caused by their tinnitus, which is ringing in the ears, which is also service connected. But where the migraines didn't start in the service, but the they're caused by the service-connected condition. Any condition that's secondarily related can also be service-connected on a secondary basis. Non-convincible personality disorders. This slide is here because you really need to look for this, especially with older, I shouldn't older, it's all relative, veterans, especially from the Vietnam era, or veterans who served in the early Gulf period. Oftentimes, the military would process individuals out with personality disorders when really they were having a psychiatric issue in the service. It's easy for the military to get rid of someone and saying they just have a personality disorder. If you ever see that, just sort of look closely, because likely there's an underlying mental health condition which can be diagnosed and service connected. But a personality disorder, and for that matter, any genetic condition or congenital condition that someone was born with, is not going to be able to be service connected. Okay, next slide, please. So nexus. So again, current diagnosis, which was the last slide, nexus between the two. It can be a casual relationship. Again, it can be direct or secondary, like we just talked about. 1151, that's a reference to a section of the CFR where if you're injured and have a disability that's due to VA malpractice at a VA medical facility or clinic, that can also be service connected and compensated based on the schedule of disabilities in the CFRs. And again, you need competent evidence to connect the two. Usually that's a medical opinion, but it can also be a treatise or a medical article saying that such and such condition is often related to this type of service or this type of exposure in service. One thing that is very unique in the VA disability benefits area is the standard that is used by the VA. It's at least as likely as not. So it's 50% or greater. Most of you out there, and lawyers at least, are usually deal with more likely than not preponderance. In VA world, it's not preponderance. It's less than a preponderance. So it's a pro-veteran standard, at least as likely as not. You really need to use that to your advantage if you're advocating for veterans. Oftentimes, the VA will send claims to examiners to adjudicate a claim, and the examiners will deny, and they'll say that I can't connect this person's hearing loss to service without mere conjecture. I can't, their hearing loss is likely due to their post-service work in a factory. That's the wrong standard. It doesn't matter that it could be the result of their post-service work in a factory. It could also be the result of their time in the service around machine guns. So again, if it's at least as likely as not, it needs to go to the benefit of the doubt, needs to go to the veteran, and the benefit needs to be awarded. So just really look for that if you're advocating in this space, because it's something that's a great tool to have as an advocate. Okay, next slide, please. Okay, so these are the current compensation rates. As I said a few slides ago, it's from 10% to 100%, 10%, and it's supposed to compensate for an individual's occupational impairment. Someone 100% rated is presumed to not be able to work at all. Someone who is 10% rated is presumed to still be 90% occupationally capable. It's sort of a weird mindset to get into, but that's how these rules were made, over half a century ago. And as I also mentioned, most of the conditions are not rated at each 10% increment. Mental health conditions, for instance, the only possible ratings are 10%, 30%, 50%, 70%, or 100%. Migraines, for instance, are 10%, 30%, or 50%. So not all conditions are going to have a step at each 10%. And in order to know which each condition what rating is possible, you look to the Code of Federal Regulations, which has every conceivable condition that a veteran might have. And then they have the percentages for that condition, and then the symptoms that that veteran has to meet in order to be evaluated or rated at that percentage point. And again, these are the current rates as of December 2022. They go up most years by a few percentage points. Yes, so again, measures functional loss and earning capacity. You can be temporarily disabled or permanently disabled. It's not like Social Security where it needs to be, I think it's permanent, which is defined as at least for the next 12 months. That doesn't exist in VA. You can combine ratings. Clients get very, very confused about their combined ratings. And you kind of have to, I mean, lawyers aren't great at math, right? I'm not either, but you have to think about it like a discount on a discount when you're shopping at a sale. If a veteran is rated 70% for PTSD and has a 50% rating for migraines, that doesn't make them 120% disabled. You have to add them together by taking the highest percentage first, which is 70%, which leaves the veteran 30% able. And then you apply the next highest disability, which is 50%, to that 30%, and 50% of 30 is 15. And then you add that back to 70, which is 85, which would be rounded up to 90%. So someone with a 70% PTSD rating and a 50% migraine condition would be combined rated 90%. Veterans will call you, your clients will be like, I should be rated 120%. Why am I only 90%? And you got to just work through the math with them. Sometimes veterans have 20 different ratings from 70% all the way down to 10%. That I can't do that math. I can do 70 and 30%, but not when it's at 10 conditions. There are calculators online that can walk you through that and figure out how the veteran gets to their combined rating. Just know that if you get to the 5 point in between 10 points, it rounds up. So if you get to 95%, you're up at 100%. If someone's rated 75%, then they're up at 80%. So they do round up when you get to the 5s. No pyramiding. That just means you cannot be receive 2 separate ratings for the same symptoms. So this often comes up if someone has a musculoskeletal condition, which also results in some nerve conditions. You want to make sure that each symptom is compensable and rated by the VA, but you can't count symptoms more than once. But the VA is required to give you the highest rating possible for each symptom. There's also something called total disability for individual unemployability. This is a big one. It's hard to get to 100%. So if someone's not able to get to 100%, but they have one disability rated at 60% or multiple that make up at least 70% combined, and that veteran is unable to work because of the condition, the service-connected condition, then they can be paid at the 100% rate, even though they haven't met the scheduler combined rating. Okay, next condition, or I keep saying condition, slide please. So I'm not going to spend too much time on these. DIC is a benefit that can be paid for eligible survivors. Death pension is another one. Death pension is means tested, so you won't see too many people on that. But DIC is a big one. If you get a call from a widow who's a surviving spouse, this is the eligibility criteria to get the DIC benefit. Next slide, please. Okay, so in 2015, the VA really pushed forms. Everything now in VA world has to be on a form, and it has to be on a specific form. It can't just be any form. So if you're going to practice in this area, you really have to be careful what type of claim you're filing, and then it's on the right form. Otherwise, the VA will reject it. There are original claims, which is the first time a client has made a claim. A fully developed claim is a subset of that, where you submit all evidence you want to submit at the same time as submitting the claim. There's a supplemental claim, which is when something's already been adjudicated and you want to appeal that decision. You can submit a supplemental claim with new and relevant evidence, which will permit the VA to reopen the claim and look at it again. And then there's what's called a clear and unmistakable error claim, which is where if you're looking in a file and you believe that there is a clear error in a previous adjudication by the VA, you can argue that a clear and unmistakable error has occurred and the VA needs to take another look at that. Q is rare, but it's great because then that means you get benefits back to the original date of the claim. Usually, you only get a retro award for a client back to when the claim was filed if you're past a 1-year window, which we're going to talk about next. Next slide, please. So this is a brief overview of the process, appeals process. You have the initial claim, which could be one of the supplemental claims or the original claims we just talked about. It gets developed by the VA. There's usually an exam, and then a rating decision is issued. You have 1 year from the date of that decision to appeal it and preserve the earlier effective date. And there's sort of 3 ways you can do that in the new appeal system that was passed in February 2019. You can do a higher level review, which closes the record and gets a higher level decision review officer to look at the decision that was just made. You can file a supplemental claim if you want to put in new evidence, or you can appeal it up to the Board of Veterans Appeals, which is based in DC and is the highest level of review at the administrative level. The turnaround time for higher level reviews is about 90 days, same for supplemental claims. For the board, if you're going to the board, believe it or not, you usually have to wait about 3 years for a decision. So those are at the regional office. At the Board of Veterans Appeals, which again is in DC, that is the highest level of review within the administration itself. To get to the board, you file a notice of disagreement with the regional office decision. You can pick 3 different lanes at the board. One is a direct review by a judge. One is evidence submission lane if you want to submit additional evidence to be reviewed by the judge, or you can select the hearing lane, where if you want to sit, well, now they're all virtually, but if you want to have a video hearing in front of a judge. I pretty much always just do direct review because I usually have all the evidence I need in. I rarely ever do hearing lane because that's going to add probably another 2 years. So we're talking about 5 years just to get a hearing with a judge. And usually I think we can get everything we need to in with declarations and written arguments. So I never really request hearings. And then a decision is eventually issued. Oftentimes the board will just remand it back to the regional office for them to do additional work or development. If for some reason you do get an unfavorable decision at the board, you can then appeal it to the Court of Appeals for Veterans Claims, which is in DC as well, but that's outside of the administration. So you no longer are within the VA, you're in the federal courts, and there's a special court set up for VA appeals. And you have 120 days to appeal that. If you get an unfavorable decision at the Veterans Court, then you go to the Federal Circuit, and then the next stop would be the Supreme Court. Okay, now real quick, I'm going to switch to my screen, and I'm going to show you what some of these decisions look like. Okay, hopefully everyone can see my screen here. So this is a decision from a regional office. So this would be what's commonly just referred to as a rating decision. And I want to go over some important things to look for and that you need to note if a veteran comes to you and says, here's my decision, I want to appeal it. The first thing you need to note is the date. So this one, September 4th, 2019. So obviously we're outside of the 1 year window, but that's the first thing you want to know because you have like 1 year from the date of mailing of this decision, which is this date right here, in order to file an appeal and preserve the earlier effective date. You can always refile in VA benefits world. It's just your then potential retroactive award is going to be tied to the date that you file the new claim. So say this person comes to me now, I file a claim on September 21st, 2023, 3 years now, the veteran gets a favorable decision. The benefits are going to go back to September 21st, 2023, not back to 2019, because they didn't file within 1 year. This claim was a claim for PTSD, and it was denied because new and relevant evidence was not submitted. This is the cover letter that goes on top of the decision. Here's where the VA informs the veteran of the different review options that are available, which we just talked about. This talks about the different forms that you need to use to perfect that appeal. So again, I can't stress, you have to use the proper form, otherwise it's not going to go through. And to make it even more complicated, the VA is always changing the forms. So if someone comes to you and this is already 4 years old, this is still correct information, but I would still just confirm on the VA website and in the regulations that these are still the proper forms to use if someone's coming to you with a decision that's old. That's that old. So that's the cover letter. Under the cover letter is the actual decision itself. Here's more information about the review options. This is the actual decision. One thing to note is that the decision was actually September 1st, 2019. The notification letter, which is on top, was September 4th. The 1 year deadline goes from the notification letter, not the date of the actual rating decision itself. This then talks about what decision was made, the evidence that was reviewed. I blocked this all out just for privacy purposes, but in here you'll see, service treatment records for this period, compensation and pension exam, this date, blah, blah, blah. And then in here, they're supposed to sort of go over the reasons why someone was denied. It's important to sort of review this because you want to sort of pick up on anything that is demonstrably not correct or untrue. But generally what's in these decisions is pretty boilerplate, so you don't have to pay too much attention to it. And then they have to cite to the various regulations that they relied upon. But the big thing to focus on is really the dates, because you got to pay attention to the deadlines to get the proper effective date. This is the second example in your materials. So again, pay attention to the date. This is May 5th, 2021. These are all the conditions that were denied. And as you'll notice that this doesn't say right away why the denial occurred. You can scroll down past the notification letter down to the rating decision itself. This was what's a higher level review appeal, meaning that the record closed for the prior appeal, and this senior level review officer didn't overturn the decision of the underlying decision maker at the regional office. Again, for each condition, we're supposed to talk about why the person was denied. Let's just take a look at one of them so you can get a sense of how frustrating this area of the law can be. So this individual applied for service connection for a cervical strain due to basically a back condition. So they recite that service records show there was a cervical or complaints of neck pain. The separation assessment from the military showed neck pain secondary to overuse. Private treatment records show neck condition. However, VA medical opinion found no link. Favorable findings. You've been diagnosed with a disability. The VA exam, January 2020, listed a diagnosis of cervical strain with invertible disc syndrome. Evidence shows a qualifying event, injury, or disease had its onset during service. Service records showed neck pain during your period of active duty for training in 2016. So you're probably wondering what's missing. Well, if you remember from a few slides ago, this person has a current diagnosis and an in-service condition. Two of the three things you need. What's missing is a nexus between the two. What reading between the lines here, what they're saying is that the VA examiner couldn't connect the current condition to the time in the service. I can tell you that's BS, right? The veteran can provide the nexus opinion based on their lay testimony about the symptoms they've had since the service. You can easily overcome this by having the veteran submit a statement saying, I started having neck pain in the service, which is, objectively demonstrated by their service records. They have a current objectively demonstrated neck condition based on the VA exam. The veteran can supply the nexus by offering their testimony in written form that the condition they started having in the service has continued to this day and the pain has been constant. The veteran can't provide medical expertise, can't provide a diagnosis, but they can provide competent evidence in the form of lay testimony about the symptoms that they've personally described. That's perfectly acceptable. So that's how you would overcome something like this. And then this goes on to say why the other conditions are denied. And it's pretty much the same thing. VA exam says left knee, tear, evidence shows left knee. So the thing that's missing is the nexus piece. And you'll see this a lot, especially at regional office level decisions, which are honestly not the best quality from the VA. Oh, we had a question. Oh, I will speed it along. Okay. Just real quick, I want to show you what a board did. So this is a decision from the board. After you've appealed it up to the board in DC, their decisions look a little bit different. Here too, you need to pay attention to the date. You have 120 days to appeal to the court. But similarly, it'll say the date. It'll tell you what's granted, what's not granted, and then whether you want to appeal it. So the decisions from the board look a little bit different, and just know with the board decision, the deadline is a little bit different. Okay, let's go back to my slides, which I'll get through quickly so we have time for questions.
It looks like someone has their hand raised. Do you want me to?
Sure.
Okay. Oh, I don't know how does that work? Allow to talk, Regina. I think you should be able to unmute. Okay.
Thank you so much for the presentation. I just had one question. When you said testimony of the veteran, is it enough to submit a declaration with those documents, or exactly in what format?
Yes, everything, and it should be paper driven. Waiting for a live testimony from a client is just not worth the wait time. The VA will definitely accept a written statement from your client as long as it's dated, has their social or VA claim number on it, and then has some type of attestation at the end saying, I declare the foregoing true and correct, blah, 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 with their signature. And electronic signatures are fine. So yeah, the VA will definitely accept a written statement signed and dated by your client.
Thank you so much. I appreciate it.
Okay, do you want to put my slides back up? Here, perfect. Okay, next slide. Okay, fees. So if any of you are thinking about doing this work, you can get paid for it. You do need to be accredited by the VA. Even if you're doing this on a volunteer basis, pro bono basis, you do need to have accreditation from the VA. That can be a bit of a pain point. So if you're even remotely thinking about doing this type of work, I would just submit an application to the Office of General Counsel. Information about that is on their website. It's just a form you fill out. Then there are some ongoing CLE requirements. Yeah, if you're interested in doing this, just get accredited, and then you can assess later whether or not you want to take on a case. Fees are allowed, but they're limited. If you want the VA to withhold the fee from the client's retro award and pay you directly, the fee cannot be more than 20%. And it has to be a contingency fee based off of the retro benefits that you secure for a client. You can withhold, or you can charge a veteran more than 20% for your services, but then you need to collect the fee directly from the veteran themselves. Okay, next slide. Okay, let's see what's after this. Yeah, this is just general information about VA healthcare. You know, not every veteran is going to be eligible for healthcare. If a veteran has a service-connected condition, they will be eligible for healthcare. And there are ways to appeal healthcare determinations, but you're likely not going to see too much of that. Okay, next slide. Same thing with housing assistance. I don't handle too many of these cases, but they are something that you can do work on and appeal. But there are various programs administered by the VA for housing assistance for veterans, including if a veteran, you know, is disabled and they need a wheelchair ramp, or they need to make some ADA changes to their bathroom to accommodate their service-connected condition. There are programs through the VA in which the VA will work with contractors and pay for those types of accommodations to be made. Okay, next slide. Education benefits are a big one. I'm sure you've all heard about the GI Bill. There's also the post-GI Bill for veterans who've more recently served. These benefits are also eligible for some dependents. And sometimes you will have clients come to you with issues about VA wanting to recoup some education payments because a veteran maybe didn't complete all their courses, or the VA is going, or the veteran's going to a non-accredited institution. But again, you don't see too many of these. Most of what you see is going to be the VA disability compensation benefits that we've spent most of today talking about. Okay, next slide. Here's some other ones. Veterans, if they need special clothing because of a condition, there's an allowance for that. Aid and attendance if a veteran is so disabled that they need the help of another person to do their ADLs, their activities of daily living, that's a benefit. Then there's various life insurance programs that service-connected veterans can be eligible for, which is basically life insurance at a very, very low premium. Okay, next slide. Burial benefits. I'm not too familiar with these. I don't do too much work in this area, but if family members can usually be reimbursed for burial expenses and costs associated with burying a veteran. And again, veteran means that definition we talked about at the beginning. Okay, next slide. Yeah, this is pretty much it. Funeral costs, burial costs. For certain veterans, they can have a burial plot in a VA cemetery, and then flags and memorial markers are also available through the VA. Again, though, this is under the Veteran Cemetery Association, which is sort of the third prong of the VA, and so not a claim that you would make through the VBA or the VHA. Okay, next slide. Yeah, for burial in a VA National Cemetery, this is just some information about that. That you do have to meet certain criteria in order to be eligible to be buried in a VA cemetery. Okay, I think that's the last slide. Yep. Okay, any more questions? I'm happy to stick around as long as I need to answer any questions. I know that was a lot of information.
It will look like we have any questions right now, but give people a minute to think things through and chew on it, I guess.
Okay.
And then if can folks access the Q&A? I just want to make sure that it's actually turned on. I think they should be able to. If not, you can also raise your hand and we can unmute you.
I see one. Oh, PACT Act. Oh, yeah, there have been some questions here. Okay. Yes, the PACT Act. So some of you, well, if you read the newspaper in the last year, you probably heard about the PACT Act. This was a law that was passed by Congress that expanded some of the presumptions eligible for different toxic exposures during the service. I've talked briefly about presumptions There are presumptions of certain conditions. The big one being Agent Orange, which I'm sure you've heard about for Vietnam veterans. If a veteran served in Vietnam and touched boots down in Vietnam, there's a list of conditions: diabetes, hypertension, ischemic heart condition, prostate cancer. If a VA just spent 10 minutes but had a foot on the ground in Vietnam and has any of those conditions, it's presumed to be service connected. The PACT Act expanded eligibility for that, for Agent Orange exposure, but also, and more importantly, for burn pit exposure for some of the more recent conflicts in the Middle East. If a veteran can show that they served in the Middle East and near a quote unquote burn pit, there are all these respiratory and rare cancers that are not presumed service connected. But the PACT Act also expanded presumptions for certain veterans that served at Camp Lejeune, which is a military base in North Carolina that tragically had toxic groundwater for decades, and thousands of militaries personnel and their families were exposed to the toxic groundwater and have suffered terrible diseases from cancer to birth defects. And so the PACT Act addresses that as well. So definitely a big win for the veteran community in terms of recognizing some hard to service connect on a direct basis conditions. I see another question here about Agent Orange exposure during Vietnam. I think I answered that briefly. Yes, there is a whole list of conditions that are presumed related to Agent Orange. The important thing there is, in order to get the presumptions, you need to be able to show that the veteran served during the Vietnam conflict and was in Vietnam or within what's called the blue water of Vietnam, which is on a Navy ship, usually within a certain mile distance from the shore of Vietnam. Then the presumption applies. It can get tricky. I have a number of clients who served in the United States, but they served on Air Force bases where Agent Orange was stored, and they have they've offered testimony about moving the Agent Orange containers onto airplanes and off of airplanes. But the fact that those sites are not part of the eligible presumptive sites, the presumption doesn't apply. So you run into some issues there, even though they offer credible evidence about seeing Agent Orange and smelling it and being near it. The presumption doesn't apply, and so you have to get it on a direct basis. I hope that I didn't confuse the question there. Yes, Air Force bases in Thailand do apply, but not all of them. It's the ones near the border, and usually for Thailand bases, it's not enough to say you were on the base. You have to offer credible evidence and testimony that you were near the perimeter of the base. Because in Thailand, Agent Orange was used around the perimeter of the bases in Thailand to defoliate the perimeter of the bases. So you get into this bizarro world where you can put your veteran on the base in Thailand, but the VA says that they weren't close enough to the perimeter, even though your veteran testifies that they, mowed the perimeter. The PACT Act did do some favorable expansion of the presumptions around Thailand bases, but Thailand bases are not as easy to get service connected as stepping foot in Vietnam. And the same thing goes for the DMZ in Korea. If you have veterans who served in Korea and they testify that they were in Korea and near the DMZ, it's a strange situation where they have to be right on the DMZ in order to get the presumption of exposure to Agent Orange. They can't be, there's no defined zone, but you get into a weird back and forth with the VA on that. What are the most common issues you would deal with when helping ALRP clients? I'm not sure if that's a question for me. On my personal experience with being a panel attorney, it's usually helping veterans apply for disability benefits or individuals apply for disability benefits. from LTD policies, but that's just because of I think my areas of expertise that I have on the ALRP panel. I'm not sure if you want to take that one, Sloka.
Sorry. Yeah, I think like you mentioned, it depends on the attorney and what their areas of expertise are. And if you are practicing in a certain area, we can talk more about like what specifically within that area we see the greatest need for, I think.
Anyone have any other questions?
I think that's, if there are no other questions, I think we can wrap things up. Did you have anything else you wanted to mention, John?
No, just my email address is on the slide. Feel free to reach out if you have any questions. I'm happy to go over if you want to get into this area of the law, answer any questions you have, or look at any filings you want to prepare. It's a exciting area of the law, but it can be highly technical, like I guess most areas of the law.
Great. Well, thank you so much for presenting for us today. And thanks everyone for attending. Again, you'll be redirected to a little survey, fill out the survey. I will be in touch by the end of the day tomorrow with your certificate of attendance and with the link to the video recording. And we look forward to staying in touch with you.
Okay.
All right.
Thank you.
Have a great afternoon, everyone.
Bye.